The Cuyahoga County Council Operations and Intergovernmental Relations Committee meeting for Tuesday, March 29, 2016 is called to order, and the clerk will please call the roll.
Calling the roll, Mr. Miller.
Here.
Ms. Simon. Here. Mr. Brady. Mr. Brady is absent. Mr. Germana. Here. Mr. Greenspan. Here. We have a quorum.
Okay, thank you very much. Do we have just the one for public comment?
Yes, we have Miss Linda Mayer.
Okay, Linda, if it's okay, I'm going to hold till we hear the legislation, and then we'll call you up as a witness on the legislation. Is that okay? Okay, fine. Okay, and on the minutes, the minutes from the last meeting on March 1st, 2016 are in your packet. Can I get a motion for approval? Second? Okay. It's been moved and seconded to approve the minutes from March 1, 2016. Any further discussion? All those in favor say aye. Aye. Any opposed say no. Ayes have it, and the minutes are approved. And matters referred to the committee, ordinance 2016-0002. Ms. Christina.
Ordinance 2016-0002, amending titles 4 and 5 of the Cuyahoga County Code to clarify the ethical rights, responsibilities, and prohibitions applicable to elected officials, employees, board members, contractors, and lobbyists of Cuyahoga County.
Thank you very much. And based on various testimony that's been provided and also the recommendations from the Inspector General, a substitute has been created, which we're going to get to in a couple minutes. And also I would bring to everybody's attention that the comparison document, which compared this language proposed in this ordinance to the current language, that comparison document has been updated, and it's been sent to each of you by email so that you have a current version. It's about 50 pages long, so we did not print it out to save on paper. So you have that available. And at this point, I would call forward Ms. Mayer to give testimony.
Hello.
Good afternoon.
Good
Welcome to the
afternoon.
committee.
Janice Patterson and I looked over the newest of the new that's been online. I'm sure there's even newer since we saw that last night. But we just had a few things we wanted to say, most of them great. We think the really good additions are 3 places where you've restated some state law, which we think is great for the emphasis, namely the new section 403.03H on sexual harassment, section 413.13 on partisan political activity, and also all the elaborations to section 406 on the whistleblower rights and responsibilities. We think it's good that all those things are in there for handy reference. We also like the references to gender identity, and we like that you've changed may to shall. Back on page 22, I think it is. No, I'm not sure where that is. Okay, it's in chapter 407.01. This is all written, so you can see this. On the Inspector General's obligation to refer violations to the appropriate civil, criminal, and administrative authorities. And we like the fact that the PRC will be required to make quarterly, is it quarterly or semi-annual reports to the council, just as the Inspector General is. So we think those are big improvements. And then we still have a couple of suggestions, which are also on the handout I hope you got. On the use and misuse of official position, first of all of the things under that are listed. They're all misuses. So just why not take out the word use and that's so minor. But it does read, the way you've fixed it, it does read as though a person may be able to perform these tasks as long as just compensation is provided. So who decides what's just, and what if it happens time and time again? That almost alters an employee's job description. Maybe the employee doesn't complain because he or she likes to get the extra money. So just a thought. Also in section 403.03H on sexual harassment, it reads better without the initial words abuse of his or her authority. If you just would cross that out, this is also kind of minor. And then maybe if you cross it out, there's an unspoken thought that it might be okay to subject a parallel employee or even a superior one to such abuse. So another thought. Then on page 23, and this is a revision to a section that was in the previous or the original proposal on contractor training applicability. Whether or not the word exceeds might be better explained by will exceed, just because, well, otherwise it's after the fact. You have to wait until after they exceed to be exempt. Anyway, page 23, this is another little editorial thing, but there's a very good definition of notice, the word notice, and it's at the total end of a list of many kinds of notices. And we thought it might look better up front for the cause of user-friendliness. Then as two overall thoughts, each time the citizen members of these boards and commissions are mentioned, it would be perhaps a good thing to mention compensated or uncompensated, since that seems to be an important criteria. And the second thought was, is this proposed legislation sufficiently clear about the consequences of being charged with violating ethics laws? Yes, I know that penalties are spelled out in all the referenced ORC statutes. It tells what kind of misdemeanor they are or what kind of fine is imposed, etc. But not all county ethics infractions have got ORC counterparts, and so it's not always clear what the consequences will be. So those are our small comments, and as you can see, we're coming around to thinking that you're doing a great job on this.
Okay. Does anyone have questions for Ms. Mayer? Okay, thank you very much. The next thing that I would like to do is to consider adopting the substitute, which would make that substitute the version of this legislation that's before the committee. And if someone is amenable, I would like to have a motion to accept the substitute and then to call forward Mike King from our staff to explain the changes that are included in the substitute.
Mr. Chair, I move to substitute ordinance 2016-0002 with the proposed substitute that's in our package.
And is there a second? Second. Okay, and also to Ms. Mayer, I would make you aware that this is This is the same substitute that you're working with. There's a couple of other things that have come up since that will be further discussed, but there's not anything different in the substitute than what you were working with. Okay, please proceed.
Thank you, Mr. Chair. Michael King, council staff. I'm just going to quickly go. I sent all of you this one-page copy of the summary of the changes that are included in this proposed substitute. And pretty much all of these changes were either discussed at a previous committee or they were prompted by the Inspector General sent over a list of comments and questions about the pending legislation. And then finally, there were a couple changes either made at the request of the Law Department or the Personnel Review Commission. So I'll run through those quickly now. There are approximately 9 amendments in this proposed substitute. The first one is on page 2, and this was a clarification made at the request of the Inspector General. And this is simply to clarify which sections of the Ohio Revised Code we are incorporating into this ordinance. And the one clarification in particular that the IG requested be included was a reference to Chapter 123 of the Ohio Administrative Code. We had referenced 124, which is the Civil Service Code, but the 123 is the administrative code at the state level and also applies to county employees, except where we specifically exercise our home rule authority and deviate, which we've done in certain instances in our Civil Service Code, but wanted to make sure that was clear. The next amendment is on page 5. And this was again a clarification made at the request of the Inspector General. And as Ms. Mayer mentioned, this has to do with the misuse of official position. It says that no elected official, employee, or board member shall, and then the language read, require, coerce, or request without offering just compensation. Grammatically, that was a little unclear. We wanted to make clear here that no elected official, employee, or board member shall request without offering just compensation, require, or coerce, making clear that even if you offer just compensation, you're not allowed to require or coerce an employee to do something unreasonably outside the scope of their employment. But you can still request as long as just compensation is offered. The next amendment is at the bottom of that same page, page 5. This was added at the request of Chairman Miller. This is adding back into the Ethics Code reference to sexual harassment and adds specific prohibitions that would constitute a misuse of official position. It doesn't necessarily encompass all forms of sexual harassment that may be legally prohibited or identified at the federal or state levels, but for it does encompass a good and significant amount of what would normally be considered hostile work environment or quid pro quo sexual harassment. So that was some additional language. On page 11, 13, and 17, starting with page 11, there is now an explicit prohibition against discrimination on the basis of gender identity. So that was added to the 3 sections applicable to elected officials, employees, board members, as well as contractors and lobbyists. At the bottom of page 11 and onto the top of page 12, there is an amendment, again requested by the Inspector General, to clarify that the section applying to partisan political activity is really only applicable to classified civil service employees, as that is what it applies to under state law. There was, I guess, potential for some confusion there that it could go beyond classified civil service employees. So that was simply intended to clarify that. The next amendment is on page 17. This looks like a pretty big amendment. It's not as complex as all of that. This was mentioned at the last committee meeting to clarify and sort of break out the whistleblower rights and responsibilities of employees as compared to general whistleblower rights and responsibilities. And the big issue here is employees have the right to appeal adverse employment actions or retaliation brought against them for filing whistleblower claims. So one of the issues that we ran into, and this was at the request of the Law Department, was that if an employee makes a complaint of a violation under state or federal law, then the Ohio Revised Code provides that their only remedy, notwithstanding any other provision of law, is to file an appeal with the State Personnel Board of Review. So we wanted to make it crystal clear to employees in this instance that if you are filing a whistleblower complaint under any of those laws, that you have to follow that route. If, however, you are filing a complaint under any local county law that doesn't apply to any state or federal law, then you don't have appeal rights to SPBR, and you have to go to the Personnel Review Commission, which is the local civil service commission, which will hear those complaints. And again, they typically do deal with disciplinary cases and will, under normal circumstances unrelated to whistleblower complaints, and have the expertise to be able to adjudicate those types of claims. So really, we just wanted to clarify and specify how that was going to work. So I know Todd is here. He helped draft some of this language. So if you have any specific questions about that, at either now or later on, I'm sure he'd be happy to weigh in. So the next amendment is on page 20. And this amendment was, again, at the request of the Inspector General. And it's paragraph G. And it basically is intended to mirror section 204.01 of the county code, which establishes the IG as an agency of the county and specifies its responsibilities in that section. And there was a discrepancy between that section, which said that the IG shall refer other violations that don't fall under the IG's jurisdiction to other enforcement authorities. This language said may refer those violations. So we changed may to shall in this instance to reconcile those two sections. The second to last amendment in the proposed substitute is on page 21, and that was requested by the Personnel Review Commission. If you recall, in the last proposed substitute, a number of duties and responsibilities that are currently under the Personnel Review Commission under the current ethics code, but are practically being performed by the Department of Human Resources, including posting of whistleblower policies and certain types of training and other education related to ethics, that those responsibilities have now formally been moved from the Personnel Review Commission to the Human Resources Department, as that's how it's been operating. The PRC requested this language be changed here to clarify their responsibility in the role of ethics enforcement, and added the language requiring them to provide an annual report to council detailing employee ethics training, receipt of ethics laws, and posting of whistleblower policies. So it's, I think, intended to reflect more of an oversight role to make sure the county is complying with this ethics code.
And Mr. Chair, if I may, just comment on that. That, Mr. King, puts this ethics ordinance consistent with the charter, correct?
Correct.
Okay. And the way it's written now, it's ambiguous. This amendment will clarify the ethics law with the charter, correct?
Yes, that's correct.
All right, thank you.
Mr. Chair, can you elaborate on that? So this
So
clarifies an ambiguity about which department or agency is going to oversee the training for ethics?
well, as you know, we cannot, through ordinance, amend the responsibilities that are assigned in the charter. So basically what the PRC had indicated in their communication relating to this amendment was that as of right now, the PRC is the only charter entity with responsibility to ensure compliance of county ethics policies. So some of this comes down to how do you interpret responsibility to ensure, or authority to ensure compliance with ethics responsibilities. I think previously some of that meant that they would actually be on the ground posting policies, making sure things were actually doing some of the more administrative clerical work that needed to be done. This is intended, I think, to clarify that their role is somewhat of more of an oversight role, and that they're going to make sure that HR is fulfilling its functions in the code and report to council annually as to their findings. That's basically how it's been realigned. So it's not the responsibilities that are here reflect the language that's in the charter, and we're basically just correcting the individual responsibilities to reflect how things are currently operating, who's actually doing what. So. And then the final amendment is at the bottom of page 21, and that's basically just correcting a clerical error in the previous proposed substitute where the Personnel Review Commission is being, the duty is being shifted over to the Department of HR. So with that, those are all of the substantive amendments in the proposed substitute, and I'd be happy to take any questions.
Are there any further questions on the, on accepting the substitute? Here-
Amend something, accept the substitute, and then amend from there.
Right,
Sure. So move.
okay. The motion has been made and seconded to approve the substitute as the operating version, and hearing no further discussion, I'll call for the question. All those in favor say aye. Aye. Any opposed say no. So the substitute is accepted, and it now becomes the working version of the legislation. And I understand that the law department had a minor technical change that they wanted to put forward. Is that correct?
That is correct. We would like to make an amendment to Chapter 406, whistleblowers, Section 406.01A.
Could you give us a page, please?
Sure, page 17.
Mr. Chair, do we have that amendment in writing?
I do not have that.
Is that this amendment?
No, that is not. I was just going to propose it.
Let's hear if the amendment is not complex, we can approve it verbally. If it's complex, then we're going to have it put into writing. So
Understood.
let's explain what you have in mind.
In 406.01, Section A, at the conclusion of the first sentence, which ends under Section 117.103 of the Ohio Revised Code, we'd like to add an additional provision which covers other entities that an employee may report to under the revised code. But instead of listing every other entity, we would propose adding the language or any other entity as provided in Section 124.341 of the Ohio Revised Code.
Mr. Chair.
So can you explain what the impact of that is?
Well, what we've provided in the first section, we've listed specifically entities in the first part of the revised code of where someone can report a violation of state or federal law. What is not included is additionally there is a second paragraph which also allows them, instead of filing a report with these entities, they can also file it with the prosecutor, the law director, the Ohio Ethics Commission if it's a violation of the Ohio Ethics Commission, or as well as the Ohio Inspector General. So we just didn't want anybody, we believe that the provision is meant to cover that 124.341 covers everything, but we wanted to add this little provision to ensure that individuals are on notice that they can report a violation to any of these entities and still be protected under the whistleblower law.
And is that needed only in Section A and not in Section B?
That is correct.
And why is that?
Because this is just referring to the other entities that are listed specifically in the statute itself. And in Section B, what we're saying is that if there's any violation of this specific title, this specific process in place is already covered by reporting it to the Inspector General.
Councilman Greenspan?
So with that, are you suggesting that so we're halfway through that paragraph, halfway through A, where it's a 17.103 of the Ohio Revised Code, period, then you want to add language, or?
We would just add a comma.
Okay.
Or any other entity as provided in Section 124.341 of the Ohio Revised Code.
You're obviously looking down on a document. Do you have something in writing in front of you that maybe the clerk can make a photocopy and submit to us for our?
I just
visual-
had handwritten notes on the.
It's better than what we've got. So if that's possible, Mr. Chair, I just want to make sure we fully understand in
Okay.
visual form what we're discussing. I understand the context. I don't think there's an issue with the context from my perspective. Mr. King, do you have any challenge with this?
No, I think it's a proper clarification.
Okay, well, while we're getting it copied, I would like to suspend that for a moment, and I'd like to to put forward another amendment which actually relates to the same section. And what it relates to is a question in which the Inspector General and the Law Department had a difference of opinion. And what it relates to is the fact that in Section A and in Section B, it says that an employee must file a written report in order for the employee to have access to the whistleblower protections. And the opinion of the Inspector General is that we should delete the requirement of a written report so as to expand the scope of whistleblower protection. The opinion of the Law Department was that deleting the requirement of a written report could create a situation where an employee would be subject to some disciplinary action which had nothing to do with any whistleblower activity, but then the employee recalled that they made some verbal complaint about something, and on that basis claimed whistleblower protection, and the Law Department felt that could open us up to problems that we really don't need. And what I am suggesting as somewhat of a compromise, this language that Mike King prepared for me that you have on the additional sheet says that we retain the written requirement, but we specify that it has to be clearly explained to all employees as part of their employee orientation that this written requirement exists. And so it would read, the annual training provided to employees as required in Section 403 of this code shall include a notice to employees enumerating their whistleblower rights and responsibilities, including the requirement that an employee must submit any initial ethics complaint in writing to properly exercise his or her appeal rights in the event of whistleblower retaliation. And it was also pointed out that that an employee could even submit a written complaint anonymously if they retained a copy. And at the point at which some retaliation occurred, they would then have to produce the copy, and they would then no longer be anonymous, but they would still have whistleblower protection available. So that's the amendment that I'm proposing, and I would ask if there's any comment on that before I make a motion. Okay, hearing none, I'm going to move that the legislation be amended to include this Section C. Is there a second?
Second.
Any further discussion? Yes.
So, as it's written here, the anonymous whistleblower, that's not even mentioned.
No, it's not mentioned here. That was just added by clarification. That just to make the point that that having a requirement of a complaint being submitted in writing does not even preclude that it could be done anonymously if someone really felt the need to do so.
Okay, well, I'm just wondering if by reading this and not saying anything about anonymous, an employee would think that they couldn't make a complaint unless they couldn't make an anonymous complaint because it has to be in writing.
Mr. Miller and I both looked at Mr. King at
Yeah,
the
sure.
same time.
Yeah.
To your point, Councilman Germana, there is potentially that interpretation. There's nothing specifically saying that it can't be anonymous either. I think the anonymous circumstance, from just by way of illustration, if an employee were to file an anonymous complaint on their supervisor, and the supervisor were to find out by some process of elimination that it was this employee and took a retaliatory disciplinary action against that employee, if that employee retains a copy of the written complaint, well, they're outed, so to speak, because they've been retaliated against already, but they can still file the initial complaint anonymously, and then after the fact would still have documentary evidence to demonstrate that they were the ones who filed the complaint and that they were retaliated against as in response to having filed that complaint. So I think that's really the scenario that Chairman Miller was alluding to. But you're correct. There's no specific mention of anonymous versus non-anonymous complaints. The only other thing I'd note is that there's nothing prohibiting employees from making anonymous verbal complaints or identifiable verbal complaints. It just limits their appeal rights in the case they don't file something in writing. So they can still file a complaint. It just means that if they're retaliated against, they may not have the same remedies that they might otherwise have.
So does it say anywhere in here that an anonymous complaint can be made?
I believe, yes, the Inspector General ordinance, and I can confirm this for you, I believe does say that the Inspector General is to set up a whistleblower hotline for the receipt of both identifiable, and it doesn't say identifiable, but anonymous complaints. So the infrastructure is set up, anybody can file an anonymous complaint.
Okay. I think that's important. Because,
It is.
a lot of people would not make a complaint if
Well, that is one of the things that would be explained to people when they're as part of their training, when they're required under this section to be told what their whistleblower rights and responsibilities are. That would be included. Okay. Any other questions on the amendment? Hearing none, all those in favor say aye. Aye. Any opposed say no. Ayes have it, and the amendment is included. We're now going to revert back to the language that was submitted by the law department, and the amendment is proposing to change the period to a comma at the end of the word code in the middle of section A of 406.01 and add or any other entity as provided in section 124.341 of the Ohio Revised Code. Is there a motion to include that amendment?
So moved.
Second? I'll second. Any discussion? Hearing none.
Wait,
question, okay, because I'm seeing that section 124.341 is mentioned in the second sentence here.
And the first. In the beginning of that.
And the beginning. So why are we doing it again? I mean, it's at the very beginning, it's talking about 124.341.
The reason why this is being added is to make it clear that the report is not limited to being filed with the person supervisor, appointing authority, or office of internal audit created under section 126.45. But in addition to that, you may also file the complaint with the other entities that are allowed under section 124.30441 of the state code, which includes the county prosecutor and some other entities, and that's the purpose of it.
So if I think if I may speak, I may be able to add some clarity. So the first, in accordance with the section, refers to any employee under that provision. The amendment basically refers to any entity subject to that provision. So one is employee of, am I right? Looking at that interpretation?
No, the any other entity is meant to add the other entities that are specifically listed in the revised code without specifically listing all of them
Right.
in there.
The first reference to the code section refers to an employee, any employee who becomes aware. The second reference, the amendment, refers to the entities to which the code is applicable. Right, so one deals with employees, the other deals with entities. That's the reason for the two different references, correct?
Well, they both deal with an employee who they report to. If it makes it easier, we could maybe you take the first part out and say, and just start with any employee and end with any other. But it's nice to have that 124.341 up front so everyone knows that's where they need to go if they have a violation of state or federal law.
And I'm trying to be, I think a practical perspective is to leave it as is. I'm just providing a context that I believe the first reference is to employees under the code. The section are the applicable entities under the same code. I'm trying to be practical, not legal.
Yeah, it appears that in the first line, you're referring to the general process of dealing with whistleblower problems. It's in accordance with the 124.341. That's the state whistleblower section. Am I correct?
That is correct.
So you're saying that that employee may file a complaint in accordance to that section. Then at the end of the sentence, you're talking about who you're allowed to file that complaint with, and it allows you to file it with the various listed places like the supervisor, the appointing authority, and so on. And then it also says, or any of the other entities that are allowed under the state code section. That's what you're saying in the ending section that's proposed to be added. Further comment? We did have a motion and a second. Are you content, or are you still in doubt, Councilman?
No, I understand, but it's confusing. I mean, will an employee that's reading this understand what this is saying? I'm just wondering if it's
Mr. Chair, if I may comment. One of the things I think one of the reasons I believe this amendment is prudent is because I think an employee could currently read this and misinterpret its intent. Basically, right now, what we're saying is, the purpose of this section is to say, if you're filing a complaint under state or federal law, you look to 124.341. That is where your whistleblower complaint needs to be governed. And in doing that, we've stated, the section talks about filing complaints with some of the entities listed, but not all. If it's left as is, I don't know that this is necessarily the final legal conclusion you'd reach on it, but it could be misinterpreted. It could be an unintended consequence to say that if you're filing a complaint with another entity that's listed in that section that isn't specifically already mentioned in here, that this section doesn't apply and that you don't have those rights. So adding that extra language helps clarify, in my mind, what was intended, which is that if you are an employee filing a complaint under this section of the revised code, we're not intending to exclude any of those types of whistleblower complaints from this process.
What I would like to suggest, in just a bit, I'm going to suggest that we hold the legislation for an additional week so that we can review the recommendations that were made by the League of Women Voters, and this doesn't slow anything down in the long run, because we already have a meeting scheduled for next week to review the Inspector General's report, and we can just add this to the agenda, and we can still make the April 12th meeting for the full council reading. And so if we do that, I'm suggesting that we approve this amendment, but then in the meantime, over the week that we take a look and see if there's some way that we can reword this a little bit so that it's substantively the same, but maybe a little bit more clear. And I think we might be able to do that. Does that make sense?
Mr. Chair?
Yes.
Yes, it makes sense, but I wanted to propose an amendment before we conclude the meeting.
Oh, you will have plenty of opportunity to do that.
Not now.
Oh yeah, now you will, as soon as we dispose of this amendment that's on the floor, one way or the other. No, we have not voted on this yet.
Well, Germana is unsure. We should just hold it and have time to look this over.
Would you
A
like
lot of
us-
information to
would you like
digest.
to? We can do it either way. Would you like to?
Well, here, there's just one other thing that is complicated, I think, and that is, if you look at the title of 406.01, employee whistleblower rights and responsibilities, and then 02 is general whistleblower rights and responsibilities. I don't understand. What, no, that's,
To clarify how that was structured, this, before this proposed substitute, it was all one section. It was just whistleblower rights and responsibilities. Part of what we wanted to emphasize here at the law department's request was that employees are treated differently from a whistleblower perspective in a lot of instances. They have the right to appeal because they're the most likely, they have the most to lose from a whistleblower perspective. They can have adverse employment actions taken against them, and they have legal appeal rights, a due process established both under state and now county law to appeal those types of retaliation.
okay,
So that's where we
I get it.
made the distinction.
Okay, I get it.
Okay.
Because 02 is general, not employee whistleblower rights. So now, okay, so the only other question I have about this section is 5 days. What happens if the whistleblower wants to think this over and waits longer than 5 days. Does that somehow, because it says shall in 5 days, I'm just wondering what's important about the amount of days.
I believe that was a carryover from the current code. That is a whistleblower responsibility that currently exists. If you are aware of a violation, you have a duty to report it. And the 5-day window was established back in 2011 or whenever that was originally codified. That basically was carried over to the updated code as proposed here. It's a good question, but it wasn't necessarily a policy difference from what we currently have. So.
I'm just thinking, you know, this whistleblowing action, it's probably nothing really minor. Because if it's minor, you wouldn't have to be, if it's minor, you wouldn't be worrying about whistleblowing. And to say that it shall be done in 5 days, I mean, people may want to think about it before they go ahead. And also, you know, the fact that you want it in writing. I'm just thinking the 5 days is not enough time. Of course, there's, if they did it on the 6th day, well, you know, there's no penalty for, I'm just,
Yeah, Mr. Chair, I don't think it says if you're in the 6th day, you're no longer protected by whistleblower rights. I believe the intent of the time period there was to provide timeliness to an action being reported, not that you waive your whistleblower rights if you're the 6th day or beyond. Is that correct, Mr. King?
That's correct in the sense of there's no there's no requirement or limitation in the appeal process that says that your written complaint has to be timely reported.
Where is the 5-day provision shown?
It's in paragraph A of section 406.02. Oh no, sorry, paragraph B. It's any elected official, employee, contractor, lobbyist, or board member who possesses knowledge of a violation of this title shall inform the Inspector General within 5 days of discovering the violation unless the individual knows the violation has already been reported.
Understood. Okay.
you know, I just, the
Well-
5 days kind of,
Well, what this does, Mr. Chair, is it's not, this isn't here to allow us or anybody to avail themselves to protection. This is the establishment of a duty. And if somebody doesn't report in 5 days, then that's a violation of this title. So this sets up a duty, and if somebody doesn't report within 5 days, then they are actually violating this title. It's an ethical violation. If there's knowledge. So it has nothing to do with protection, it has to do with a duty.
Okay, well, we can give that further thought, and if there's no objection, we are going to hold the amendment and just see if we can get it. We support the concept, we just want to see if we can get it written a little better. And now I'm going to turn the floor to Ms. Simon, who has an amendment to propose.
And before I propose an amendment, I have to say that I still think this is confusing, this section, and I'm going to look at it between now and then. When we added section C to the whistleblower section, it just seems in contravention to another provision. So I'm going to review that. I don't think it's clear. Well, in one place it says there's a may, and then here's a shall, and there's this amendment that we just adopted, C 406.01C, says an employee must submit any initial ethics complaint. Well, why is initial there? And I don't even know what that means, an initial complaint opposed to one that comes later.
The use of the term, just to clarify, the use of the term initial in that context is to distinguish it from the any retaliation complaint. So if, say, you file an initial ethics violation, complaint of an ethical violation, and then you're retaliated against it's not that your claim of retaliation has to be in writing, it's that the initial one had to have been in writing before the,
Well, we should say the ethics complaint itself. It says ethics complaint. That's what's confusing. What ethics do you know what I'm saying? Well, we can talk about it later,
Sure.
but this says we're talking about an ethics complaint being the complaint the whistleblower is making,
correct.
opposed to reporting
But
whistleblower retaliation claim.
the thought process behind it, I guess, is that retaliation is also an ethics violation. So you can file two complaints if you're retaliated against. The one that you initially claim was a violation of the code, and then you can file another complaint saying I was retaliated against. That's another ethics violation. So that's the purpose behind that word. But
I
if
think
there's
we
further
need to better clarify.
clarification needed, we can do that.
I mean, for people reading this as an employee, I think there's things we can do to make it a little bit easier to understand.
I would strongly invite any improvement that you
Okay.
can come up with.
So the easy part, my proposal, has to do with discrimination, and it's section, let's see, 4.0310,
What page, Ms.
I don't know,
That would be page 11.
correct. So next to gender identity, I wanted to add and expression. So can't discriminate on the basis of gender, ethnicity, sexual orientation, gender identity and expression, comma, disability or genetic information.
And there are 3 places where we added the word gender identity. Are you proposing to add an expression in all 3 places?
Yes,
Okay.
why not?
And is
We
that
should
a
be-
is
yeah,
that
that's a motion.
Okay. For purposes of discussion, I'll second, and
Okay.
we'd like a little bit of discussion on why the additional 2 words and
Well,
expression.
I think it has to do with actual expression of an identity. You can't discriminate against somebody because of how they perceive themselves, but more importantly, how they display their identity perception. So if they want to wear different clothing or look different, it's how they look or appear versus how they perceive themselves. Does that make sense?
I would
does.
get it.
It does.
Gender identity really goes to a subjective, somebody's own individual view of themselves, I think. That's more personal view of themselves versus how they appear to the world. And that has to do with expression.
I would point out that the addition of gender identity was intended to make our language consistent with the enumeration that's in the county's equity plan, which I consider to be our basic document in this area. So if we add this amendment, we should consider at some point to add it into the equity plan as well. But that, so there's a motion and a second. Is the question is whether to add the 2 words and expression after the term gender identity in the 3 places where it occurs in the draft. Is there any discussion? Hearing none. All those in favor say aye. Aye.
Aye.
And opposed say no. Ayes have it. Amendment carries.
Mr. Chair.
Is that it? That's it.
Mr.
Okay.
Chair, just a question going back to the law department's amendment to which there was a motion and a second. Do we need to withdraw both at this time, or can they remain open from one meeting to the next? It's more procedural.
No, we essentially agreed to table the amendment. So I think probably there will be some slightly different language which can be moved or included in the new substitute. So what we have for next Tuesday is to nail down the language on the law department's amendment, and also to review each of the suggestions that was made by the League of Women Voters, and to see if there are some suggestions that we can incorporate into language. Ms. Mayor, did you have something to add?
I would like to contribute one thought on that subject.
Okay, please come forward. Okay, come forward.
And Mr. Chair, as Ms. Mayor's coming forward, we're talking about the four suggested items, correct?
That's correct.
So we have those 4 items plus the law department and then any additional comments from Mr. Mayor. That's what's going to be for us in 2
Right.
weeks, next weekend.
Okay.
Is that next week or in 2 weeks?
It's in 1 week. You know, we have, this is a time where there's 2 weeks without a council meeting. So- And next Tuesday was the date that the Inspector General was available. The Inspector General was not available for today, but was available for next week. So I scheduled it that the Inspector General would give us a semi-annual report. So we're just going to add this to the agenda and hopefully in a relatively short time finish this up and then hear the IG's report. Ms. Mayor.
The thing I wanted to add was to the first suggestion that we made on misuse of official position, especially performing tasks for your boss, even if you had just compensation. So I'm wondering if the language, if when you're rethinking this, and thank you for taking the time to do that, consider this possibility. Let's say you are a department chair and I'm your secretary, and you have a lot of non-county business that you have to do and you need some secretarial help. So you ask me and you say you'll pay me, and so I say sure, because I can use the extra money. Okay, so we have this thing going on. And it's wrong of you to ask me, but it's wrong of me to take it, and we're violating county work time and my paycheck, which is I'm receiving despite the fact that I'm getting overtime for working for you on company time. Now, Ms. Simon over there, she works for you too in the same department, and she sees this going on. And it should be either one or both of us is violating something, the spirit of the law. And so I'm not sure the way it's written, that would be covered.
Well,
And it has to be often a temptation.
well, I would point out that that there is another section of this ethics ordinance that says that the
Supplementary.
that the use of any county resources for any non-county work is allowable only if it's de minimis and incidental. You know, so and I'm sure that in the HR policy there is ample reference to you can't do non-county work on county time.
It sounds like consulting adults.
You know, so when you talk about asking someone to perform some non-county work and give compensation, I mean, unless it's done off of county time, I think it's not acceptable under both ethics and HR.
I would agree. I just wondered if that would be covered.
But
If you would consider that when you rethink that item.
But we'll take a look at that items and see if there's some way that we can clarify that. So
Okay.
so
Thank you.
we'll take that into account.
Thank you.
Okay, thank you. Okay, so we're I think we've got the ball well within the 5-yard line. It's very close, and we're going to look at these few additional items. Does anyone have any amendments that they have to propose or that they're thinking about other than the items that we talked about that remain on the agenda? Okay, that isn't to preclude anyone from coming up with something, but I just wanted to know what's out there. And we do know that Sonny might look in a more comprehensive way at this whistleblower section. So we're certainly open to. I don't think it's a paragon of clarity as written, so it can be improved. So if there's nothing else, then we will hold this legislation as substituted and amended. And that will conclude this hearing on 2016-0002. And I would ask if any of my colleagues have any miscellaneous business. Hearing none, has anybody signed in for public comment other than the agenda?
No, Mr. Chair.
Is there a motion to adjourn? I'll second. All those in favor say aye. Aye. Opposed? We are adjourned. Thanks very much, everybody.
That may, does make a lot of sense.